To the corridors of justice, where the Supreme Court is currently giving its decision on whether to release two Iranian nationals accused of plotting an attack on Israel's embassy 5 years ago. The DPP had filed an appeal after the two had been set free and they were required to actually remain in the country pending the determination of the apex court. Now, the Supreme Court last year ordered that Syed Nasrullah Ibrahim and Abdul Hussein Goli Safai, accused of terrorism, should be within the country but should be treated in a humane manner. Now, the two had been jailed for life by the magistrate's court, but after a spirited appeal before the High Court, the sentence was reduced to 15 years. Nasrullah and Gori were arrested by anti-terror police unit after they were caught filming and taking photographs of the Israeli embassy. Let's now cross over to the Supreme Court and listen in to the judgment by the Supreme Court judges.
1998 did not bring down the building that housed the American embassy, but, as stated, its effect is being felt up to this day. In this case, PW16, Catherine Shera Murambi, a bomb expert, testified that the RDX that the respondents were allegedly found in possession of is one of the most lethal explosives used in warfare, which, if detonated, could bring down a building as huge as the Times Towers of Nairobi. This calls for vigilance on the part of Kenyans, including judges and judicial officers. For judges and judicial officers, their vigilance has to be within the confines of the rule of law. They cannot, for instance, act on public outrage of the offenses of terrorism and ignore the law. While they must jealously guard an accused person's right to a fair trial, the court should equally guard public interest by ensuring that those who commit or plan to commit terrorist offenses do not escape punishment.